Hello my dear students, I am Dr. Manoj Sharma. Today the topic of our discussion is incentives for precaution under strict liability and no liability. As we know, accidents and injuries occur more frequently in the contemporary world due to a multitude of factors. Several types of accidents create liability for the victim and the injured. For example, there may be collision of vehicles, a medicine may cause side effects that cause injuries to the victim, consumer, or there may be an accident in a factory that injures the workers. The dangerous chemicals in a factory may escape, causing loss of life and property and raising questions of liability and compensation. We have already noticed that the law of property and law of contract are major civil laws under which actions can be filed by the claimant. However, the claims mentioned herein are not claimable under any of these laws for the simple reason that the claims are not the result of breach of promises or transactions or transfers of property. Rather, the claims have arisen because of liability arising out of accidents. Hence, the victim desirous of claiming compensation or damages has hardly any remedy under the contract law or property law. These claims are dealt with under an important branch of civil law, that is tort law. Tort law deals with civil wrongs as opposed to criminal wrongs. Therefore, the domain of tort law extends to compensation for damages, accidents, trespass, nuisance, etc. The major objectives and functions of tort law are compensation, deterrence, appeasement, etc. One of the primary goals and crucial functions of tort law is to mitigate the societal expenses incurred by accidents and strive for the equitable distribution of accident costs. From an economic theory perspective, minimization of social cost of accidents and distribution of accidental costs and the theories dealing with the same are crucial objectives of an efficient tort law regime. But it must not be forgotten that like other civil remedies, the cost of civil litigation under the tort law is heavy, and therefore, to mitigate liability, parties including the victim and the injurer often obtain insurance policies as a precautionary measure. This way, the victim and/or the injurer can take due care in avoiding the accident to avoid or minimize the harm caused and the cost of the accident. However, both precaution and insurance come at a price in terms of money and time consumed. In this backdrop, today we shall be discussing the incentives for precaution under theories of liability like strict liability theory and no liability theory. Let us first discuss traditional theory of tort liability. As explained, tort law deals with the determination of liability for torts, including accidents. The determination of liability is dependent upon various factors, including the theory of liability adopted by the legal regime. The traditional theory of tort liability mandates that the tortfeasor or the injurer has the liability to compensate the victim only if three conditions are satisfied. Firstly, the plaintiff must have experienced harm. According to the traditional theory, in order for a plaintiff to bring a lawsuit for tort, it is necessary for them to have experienced harm. In the absence of harm, a lawsuit in tort cannot be pursued regardless of the level of danger associated with the act. The second component is causation. The defendant's act, whether commission or omission, must directly result in the harm. In order to prove legal liability under the traditional conception, it is necessary for the defendant's act to not only be a cause in fact, but also the proximate cause of the injury suffered by the plaintiff or victim. The concept of causation may appear straightforward, yet establishing causality within a legal context is exceedingly intricate. the concept of causation is widely recognized as a challenging subject in philosophy, and its complexity extends to the field of law. The probability of injury can be heightened by multiple factors, such as a person working in a workplace with carcinogenic chemicals and being a smoker, especially if his parents died from lung cancer. The courts have had difficulties formulating a practical framework for determining responsibility when the potential risk results in real injury. An economist might do regression analysis to quantify the incremental impact of heredity, asbestos siding, workplace toxins, and smoking on the likelihood of developing lung cancer. But what about the courts? How do they apply these causative factors in determining liability? Now, the third important factor is breach of duty of care. The third important requirement for fixing liability under the traditional theory is that the defendant or injured person owed a duty of care to the plaintiff or victim, and that the defendant or injured person has committed a breach of that duty. Typically, the victim needs to provide evidence of more than just harm and causation in order to receive compensation from the offender. From the economic analysis of tort law perspective, it is expedient to examine the incentives available to parties if they take precautions to prevent accidents and liability. The examination of incentives to precaution shall be examined in both situations. That is, when there is no liability for the harm caused and the entire loss is to be suffered by the victim, and secondly, when the liability for the harm caused is ascertained based on no fault theory or fault theory. Now, coming to incentives for precaution under the no liability regime. Let us first examine the contours of the no liability regime and the incentives for precaution for the parties. It must be kept in mind that if the injurer has no liability for the accident and the consequent harm caused, the injurer is not likely to take precaution and spend time and money on precaution. Accordingly, the injurer will minimize the cost of precaution since there is no incentive for precaution. In cases where there is no liability to the injurer and the entire harm and cost are suffered by the victim, in such a scenario, the victim will take precautions to avoid harm. Therefore, the victim will incur the cost of precaution as well as liability for harm. In such a case, there is an incentive for the victim to take precautions to avoid and or minimize harm. As such, the no liability regime promotes unilateral precaution and does not incentivize precaution for the injurer. Now, coming to theories of liability in tort law. Now, let us consider that the liability is apportioned on the basis of various theories of tort law on the injurer and or the victim. The victim can claim damages and compensation from the injurer on the basis of various theories, such as no-fault theories. No-fault theories apportion the cost of the accident and the liability on the injurer, whether he is at fault or not. This type of theory is based on the assumption that the person who keeps dangerous things must be held liable if those things escape and cause accident and harm. These theories can be categorized as absolute liability and strict liability. Secondly, fault theories or negligence theories, where the cost is determined on the basis of which party is at fault or is negligent. Such theories take into account various forms of negligence on the part of parties, such as negligence, contributory negligence. The doctrine of strict liability was evolved in the famous case of Rylands vs. Fletcher, where the court held that the party who keeps dangerous or hazardous substances is liable if those substances escape and cause damage. In such circumstances, the victim can recover the harm caused by the injurer irrespective of the fact that the injurer was not at fault. However, with the passage of time, several exceptions were judicially recognized regarding the rule of strict liability, including the damage caused by acts of God or of a third party, etc. The Supreme Court of India in MC Mehta versus Union of India, infamously known as oleum gas leak case, invoked the rule of absolute liability. The court recognized that the exceptions to the rule of strict liability are not applicable to the rule of absolute liability, and the injurer shall be absolutely liable whether he is at fault or not. These rules of liability based on no fault are especially applicable to dangerous or hazardous activities like oil gas leaks, Bhopal gas leak cases, etc. A negligence rule is a legal principle that necessitates the plaintiffs to establish harm, causation, and blame in order to hold someone liable. In contrast to a strict liability rule, a negligence rule allows for a defense when the defendant is the direct cause of injury suffered by the plaintiff. According to negligence rule, the defendant is not held responsible if they met the required level of care to prevent the injury they did. Now let us examine incentives for precaution under no liability and strict liability. The allocation of accident costs has distinct motivational implications. Under a strict liability system, the party causing harm is responsible for both the expenses of taking precautions and the anticipated cost of accidents. Consequently, they will strive to reduce the total of these expenses. This will result in the optimal level of precaution and provide the injurer with the motivation to take precautionary measures, as it allows them to minimize their anticipated costs associated with accidents. Conversely, a rule that absolves the injurer of any accountability, known as a no liability rule, fails to produce an optimal outcome, as it removes any motivation for the injurer to take precautions. The injurer would incur the expenses associated with taking precaution but would not receive the benefits of such precautions. In the absence of liability, the party causing harm would not take any precautions, leading to an inefficient outcome. Conversely, when considering the victim's motivation to exercise caution, we observe that the converse is true. Strict liability would not provide any motivation for victims to take precautions, but having no liability would place the full responsibility for any harm on the victim, encouraging the victim to take optimal care and precaution. Strict liability and no liability can provide incentives for efficient precaution to either the injurer or the victim, but not both. Therefore, both systems encourage and incentivize unilateral precaution. Strict liability and no liability can only lead to efficient outcomes when there is a single party responsible for taking precaution, or when there are multiple parties who can take turns in doing so, as long as the party with the lowest cost of avoiding harm is held liable. When it comes to bilateral precaution, both no fault liability and no liability regimes are ineffective in creating the best incentives. This is because neither rule can impose liability on both parties at the same time. The fault liability or negligence rule in the law of torts takes care of this situation. Now let us examine incentives for precaution in cases of fault theory of liability. The fault theory of tort liability appears to provide better incentives to the injurer and victim. Fault can be categorized as a means of establishing ideal motivations for both wrongdoers and victim, as well as attaining effectiveness in situations involving mutual caution. negligence standards establish a distinction between legal responsibility and lack of responsibility by determining a standard of reasonable care and determining whether the party in question met that standard of care. Introducing a fault refers to establishing a specific level of precaution as mandated by the law. The appropriate amount of precaution should be selected to match the optimal level of precaution. In every negligence rule, the court must assess the level of precaution exercised by the parties and compare it to the appropriate level of precaution. However, it must be noted that adopting this approach leads to higher administrative expenses in the process of settling legal disputes compared to implementing stringent liability regulations and makes the process complex. Now let us discuss simple negligence. In cases of simple negligence, an individual who causes harm is only held responsible for compensating the injured party if it is proven that the injured party acted negligently. The victim assumes residual liability, meaning that they are responsible for the effects of the accident if the injurer cannot be held accountable for negligence. Simple negligence can be compared to a no liability rule as it places the remaining liability on the victim. In cases of unilateral precaution accidents where the victim is the one who might have avoided the accident, the injurer cannot be deemed negligent as it is not feasible for them to take appropriate precautions. Consequently, the victim is responsible for covering the expenses resulting from the accident, which gives him motivation to adopt the most effective safeguards, as he is not protected by any liability. If the person causing the injury is found to be negligent, they are responsible for covering the expenses of medical care and compensating the victims for the anticipated costs resulting from the accident. However, by exercising proper caution, he can prevent legal responsibility and just incur the expenses associated with being cautious. If the amount of care is established at an efficient level, the person causing harm will have incentives to exercise the appropriate level of care. It can be inferred that in circumstances where one party is alone responsible for taking precautions, ordinary negligence provides the appropriate motivation to exercise the highest level of care, regardless of whether the negligent party or the potential victim is the one avoiding the harm. Now let us see contributory negligence. According to the principle of contributory negligence, the person who caused the injury is responsible for compensating the victim only if the injurer was the negligent and the victim was exercising caution. In other instances, the sufferer retains the residual burden and does not receive any compensation for the loss. Consequently, the victim is not entitled to compensation in cases when both parties were negligent, both parties were careful, and particularly when injurer was careful and the victim was irresponsible. Equivalent outcomes are achieved when employing the principle of comparative negligence. Under a regime of comparative negligence, the victim's negligence does not completely prevent the possibility of compensation, but instead results in reduction of liability based on various levels of negligence of the parties involved. Under both systems, the party causing harm can avoid legal responsibility by exercising the appropriate standard of care. This establishes a suitable motivation for the person causing harm to adhere to the legal requirement of exercising caution. Considering that the injurer can properly anticipate liability for loss, he will have an incentive to act cautiously as he gains by investing in precautions. contributory and comparative negligence incentivize both parties to provide efficient care, but only the victim who bears the residual responsibility would be motivated to engage in an optimal level of activity. The party causing harm can evade legal responsibility by using a reasonable caution, thereby lacking any motivation to invest in precautions that cannot be easily observed. Contributory and comparative negligence yield identical incentives as a rule of simple negligence, but they may have distributive consequences by limiting or decreasing compensation if the victim is determined to be at fault. Now let us conclude. Due to the impossibility of both parties sharing the accidental loss equally, traditional legal procedures focus on providing incentives to either one of the parties to take action. The negligence rules, such as simple negligence, contributory negligence, and comparative negligence, assign the responsibility of bearing the consequences of negligence to the victim. These rules effectively incentivize the victim, who is the residual bearer, to exercise caution in his actions. On the other hand, strict liability-based negligence rules, such as strict liability and absolute liability with negligence defenses, assign the responsibility to the injurer. These rules effectively incentivize the injurer, who is a residual bearer in these cases, to exercise caution in their actions. Thus, we can conclude that the tort law should be structured to offer suitable incentives to potential injurers and victims, encouraging them to prevent accidents by taking responsibility for the external cost resulting from their actions. If the tort liability is not present, individuals who may cause harm would have to face the financial burden of taking precautions without receiving any of the associated benefits. The advantages of taking precautions are independent of the level of precaution taken. This would result in unsatisfactory level of health care and an excessive number of accidents. Tort liability ensures that a potential wrongdoer takes into account the advantages of being cautious, namely the decrease in anticipated legal responsibility. Therefore, from an economic analysis of tort law perspective, tort law should be formulated in a manner that encourages parties to take responsibility for the external consequences of their actions and to implement the most effective measures of precaution. With this, we come to the end of today's lecture. Thank you very much.